Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is What's the Impact? The role of economists in explaining injury and impact in competition cases. An essential element of any competition case is demonstrating that there was injury to competition and the particular party that is bringing the lawsuit has been injured. Proving that can be really complicated. And typically, this is a place where economists come in and try to help to explain how to judge whether or not there was, in fact, impact from the conduct that's being challenged. Today, we have a guest that's going to explain that to us very well. My co-host is Christina Ma. Hi, Christina.
Hey, John. How are you?
Good. So, Christina, what are we doing today?
So we are going to learn about how economics plays in antitrust practice, whether that be in litigation or in merger review. And we have a great guest to speak to that today. And
why is this important?
So if you're interested in doing antitrust law, you should know. And if you do antitrust law, you do know that economics can be critical in winning or, critical to a case. And as you mentioned, critical to showing injury in an antitrust case. And so we're here to speak a little bit about that today.
And what do we hope to get out of the program?
Hope to just get a brief introduction. We're not going to go into the nitty-gritties of econometric analyses. We could not do that in 30 minutes, but to give people an insight as to what matters, how we do the analysis, what questions to ask, how to get an economist involved, all those logistical things as well.
And who's our guest?
So we have Laila Haider, who is a partner at Edgeworth Economics with us today. She's also the co-chair of the ABA Antitrust Law Section's Economics Committee.
Great. Well, let's bring in our guest.
Hi, Laila.
Welcome to the program.
Hi. Thank you very much for having me here, John and Christina.
We're very happy to have you. Thank you for coming down. So, Laila, you are a partner at Edgeworth Economics. What is Edgeworth Economics?
Edgeworth Economics is a consulting firm that provides economic analysis in a variety of areas, including antitrust, labor and employment, intellectual property, and some others.
And your work focuses in part on antitrust litigation.
That's right. Actually, most of my work focuses on antitrust litigation.
So how are you brought onto a case? When do we call Edgeworth Economics? Do we call Laila and say, hey, I have, how does that happen?
So typically the way that this works is that, I will be approached by an attorney that I may know or I may not know. And there are a variety of different reasons why an economist is brought into an antitrust case, and I can describe those.
Yeah. At what point in the so you mentioned you do litigation. At what point in the litigation would you be brought in? Sort of before a complaint is filed, after a complaint is filed, in the middle of a trial?
So it really varies. And generally speaking, I have been typically contacted, after a complaint is filed, can be in very early stages of the case when attorneys start to grapple with discovery issues and what type of information would be useful to conduct economic analysis that would be helpful for the question at hand. So it really varies. Sometimes it could be that it also depends on which phase of the case. So if it is the case that, we're talking about an antitrust class action, then I could be contacted or, other experts may be contacted to provide economic testimony in that particular phase. It could be that it's in a later phase of the case, such as the merits phase, for either questions related to liability or damages. So it depends.
And what do you think of as your role? Let's think of a case team. You have a bunch of lawyers, you have some associates and partners, and then there's always an economist sitting there. What do you think you bring to the table, and how do you feel, how do you think you help lawyers understand the issue at hand?
Yeah, so this actually, relates to, why economics plays a crucial role with respect to antitrust analysis. And I think what I'll just start by saying is that, we know, of course, that the purpose of the antitrust laws is to promote vigorous and healthy competition among firms in the marketplace so that consumers enjoy low prices, see more choice, there's innovation. So there are, various reasons why we want healthy and vigorous competition. Economics, and specifically microeconomics, studies the behavior of firms, households, and individuals. And specifically, it's studying how firms, individuals, households make choices. So given that the antitrust laws and economics are both concerned with firm and consumer behavior, it makes sense that economic analysis is going to be inextricably linked to antitrust issues. And so as an expert, what you bring to the table is really, if you're a testifying expert, you are providing economic evidence to the fact finder. And your responsibility is to the court, could be to the judge, the jury, to explain what you have studied based on the industry at hand, the facts at hand, and explain those to the fact finder.
And have you ever had, as a lawyer, I'm often like, intuitively as a consumer, I think this is how the economics is going to play out because just intuitively it makes sense. How often are those intuitions wrong or disproven by the economics? Or do you have to sort of tell the lawyers, that's not how the economics are really, or the analysis really playing out?
This happens very often. It doesn't just actually happen with the attorneys. It happens amongst economists as well. And, there are complex issues at hand. There could be more than one answer that you think, you conjecture would be the case. And so often it requires a detailed, fact-specific, empirical inquiry to determine what the answer to that question is. And so you use the tools at your disposal to bring that to life.
A question that we often get is, for young attorneys coming into the practice is, I'm scared of math, or I don't know anything about economics. Do I need to have an economics background to do antitrust law? As an observer, do you think that lawyers benefit from having that background?
They would certainly benefit, but what I would say is that there is no need for attorneys to have an economics background to do antitrust work. However, having said that, I should say I continue to be extremely impressed by how much economics and even econometrics that attorneys, in fact, have learned over the course of doing antitrust work for the reason I mentioned earlier, because, of course, economics is at the heart of a lot of these issues that the attorneys are grappling with. But no, you do not need to have an economics background. Of course, it's helpful if you had one. It really is the job of the economist to explain the economic theory and the value of the economic analysis or the econometric analysis.
Right. We rely on Laila, who has the PhD in economics, to tell us what's...
Yes, me and others like me.
So as I mentioned earlier, we could spend hours and hours talking about econometric analyses and its role in antitrust. We wanted to focus a little on, or specifically on, antitrust harm. It's something that is relevant whether you're investigating a merger or whether or not, or civil or criminal investigation or litigation. There has to be some sort of cognizable antitrust harm that you identify. So could you explain a little bit, just at a very basic level, what is the harm that we're trying to identify and measure?
So just very simply, antitrust harm or antitrust injury, the terms are used interchangeably, is when a customer pays a higher price than it would have absent the alleged conduct. So I'll say that in a different way. If it were the case that the customer would have paid a lower price were it not for the alleged bad conduct, then that means that that customer sustained antitrust injury or was harmed.
And so I can see how mergers, obviously, as a result of the merger, prices might go up. What other kind of conduct would we be worried about as potentially causing that type of, either prices going up or innovation going down, as you mentioned earlier, or, quality going down?
Yeah, so there are a variety of different conduct that can result in antitrust harm. I'll give some examples. So price fixing conduct, of course, is one. Bid rigging conduct, market allocation. So if we're thinking about, suppliers decided that they will, split, say, the geography of the United States such that different suppliers will sell to customers in different areas, that conduct could result in antitrust harm. Monopolization conduct as well. So this would relate to business practices such that would result in an increase in sales or an increase in market share. Now, those business practices do not, may or may not be justified practices. So it is typically a very detailed analysis that is required to determine whether, there is in fact antitrust harm. But those are the different types of conduct that people think about.
And it's possible that the same analyses are used to evaluate each of those. But let's talk a little bit about price fixing, which seems like an easy concept. We fix prices, or two competitors agree to fix prices. Say, for these microphones, $20 for the microphones. How do you, for the most part, the evidence isn't smoking gun evidence. So how would an economist show that there was such price fixing or that there was harm with respect to price fixing?
Yeah. So the question for the economist is not whether business people got into a smoke-filled room and whether they talked about prices or not, right? Economics and even econometrics is not able to answer that question. However, what you can use economic analysis for, and specifically econometrics for, is to determine whether it was the case that prices to a particular customer or more than one customer were elevated during that particular period that you're concerned about, once you've accounted for a variety of other factors that would explain prices during that time period.
Okay. And for monopolization, which I think is a topic of interest to a lot of folks with all these large, the Amazons, the Googles, the Facebooks, what type of monopolization conduct are we trying to capture, and what kind of econometric analyses would you do to say that was pro-competitive, that was anti-competitive?
That's a great question and a difficult question. So with respect to monopolization, the question really is whether the market share that particular supplier has gained, whether that is because of business acumen, because they came out with an incredible innovation. And so those are legitimate reasons to have a large market share. If it were the case that the company or the business is engaging in practices that impede entry from other suppliers, then that's when it starts to be questionable. Even then, and this is going back to what I said about it being a very detailed, fact-specific inquiry, and this goes to your point about the pro-competitive justifications. They're often, if we think of exclusive dealing or some of these other types of allegations, there can be an efficiency-enhancing reason to have an exclusive deal that could result in lower costs, and hence lower prices. So the pro-competitive justifications need to be weighed against any anti-competitive effects, and that would typically, that analysis takes place in the merits phase of the case, where you really study the pro-competitive benefits and try to assess effects on price, and then outline what the pro-competitive benefits are, and then ultimately it is up to the fact finder to determine whether the pro-competitive benefits are such that it outweighs any anti-competitive effects.
So it's almost two separate economic questions. Let's isolate the harm and measure that, and then let's isolate whatever pro-competitive benefits we think are coming from that conduct or just generally, and having to balance those two. And as you mentioned, it's sort of the fact finder's determination as to how those scales weigh.
Yes, and I think what I would say is the only correction I would make to that is not so much that you're determining the harm. It's more that you determine the price effect that comes from engaging in a particular practice. And then the second question is, how does that weigh against the pro-competitive benefits?
Okay. And what data? Like if you could have, I know data is never perfect, right? And so you ask the client for X data and it never is perfect when it comes back, or has different nuances to it, or they don't have XYZ data, they don't have bid data. If you could have sort of perfect data to assess whether or not there was injury, what would that data set look like?
That's that's a hard question. I think typically, and I'll just speak with respect to, say, a price fixing case. Presently, in antitrust litigation, there is a great deal of discovery that goes on, and so what you absolutely will want is you usually obtain these types of data in price fixing cases. And again, I'm speaking generally, is you'll receive detailed sales transaction data. Those are very useful, of course, because the analysis is often based on looking at what were the prices over time that customers paid for different products at issue. You would want to have cost data. Again, it depends also on the nature of the conduct. It could, so for example, when we're talking about, say, if we're talking about a monopolization case with exclusive deals, you'll want to see, now a lot of this goes into more qualitative information, but you'd want to look at the contracts. You'll want to know, what was the timing of them, and then there are calculations that are required. Or not required, but typically are done in those types of cases to determine, how many suppliers, were locked in, how many were not locked in, and all of those go to assessing whether there should really be a concern in the first place or not about the exclusive deal. So it really depends on each case.
Right, each fact-specific case and the allegations that have been made. I expect there's been an explosion of data that's available. And you receive these data, what do you have to control for? And by control, I mean, what do you have to say? We need to sort of parse out what's happening kind of on a macro level and what's actually happening. I shouldn't say micro, that's probably the wrong term, but happening as a result, isolating the conduct as opposed to all this other noise that might be happening in the economy, in the industry. What are those factors that you're trying to control for?
Yeah, so typically, and this is why econometrics can be an extremely valuable tool, although of course there's a big caveat. Econometrics is helpful to answer these questions when it is applied properly and explained clearly. And so that is a big caveat. But this is exactly why we do use econometric analysis to answer these questions, because of course there are a variety of things that are going on when we think of how prices are determined for a particular customer or for a number of customers. There'll be different supply and demand factors at play. There'll be shocks to demand and supply. We know there was a financial crisis very recently. There was recovery after the crisis. So econometrics enables us to use economic theory, and of course you study the industry at hand, you learn the determinants of pricing, and based on that you come up with a method such that ideally you are isolating the effect of the alleged conduct so that it's not confounded by other factors. Because if it were, then that means you don't have a causal link between the effect that has been estimated by the economist and the conduct that is being alleged.
And how do you measure how good your modeling is, how good your econometric analysis is in terms of actually identifying or isolating the conduct?
So there are a variety of tools you can use. So let's say that a regression analysis has been presented in order to get at this question. Typically, what an economist will want to do is to subject that particular model to a series of sensitivity tests or robustness checks. And if you subject your model to a variety of tests, and you are coming, each time you do that, you're coming back with the same answer, then you know that the result that you've gotten is not a fluke, or it's not a result of an assumption that you made that perhaps doesn't hold up. So you really want to test your model in a variety of ways.
So sort of an iterative process. You run it different ways with different assumptions, and the basic answer is the same across all the models that might signal something.
Absolutely.
So in litigation, the plaintiffs will have an economist, defendants will have an economist. both will testify, both will critique the other's model. And there's a view, I think, within the bar that good economists sort of cancel each other out a little. Where is it? All these economists are brilliant individuals. Why is it that there's disagreement? And where is the source of the disagreement?
So there are a number of reasons why economists may disagree, having looked at, say, a particular model or a regression analysis that say, one economist is saying shows impact or shows injury. There could be omitted factors that are being pointed out. It could be the case that if there was a comparison period, which we often refer to as a benchmark period, or say you're comparing prices to another product, that typically gets quite a bit of scrutiny into whether that's appropriate or not, or whether, I talked about the financial crisis earlier. If that was your benchmark and then the financial crisis was contained in it, then there often is this concern that, it was a very, very different time. And is that, in fact, an appropriate benchmark to use? So there's just a number of issues like that come up. Another one is that it could be that the question is not, in fact, formulated narrowly enough so that it's not, in fact, actually getting at the question that should be the valid question that needs to be asked. So there are a variety of reasons why economists will disagree. And now, going to your point about the view that economists' testimony can cancel each other out, I've, of course, heard that before, and, I will say that is depressing always when you do hear that. However, I think that, that is something we all need to grapple with, both as economists and attorneys. So I think with respect to the economists, the point is that what you need to do is you need to think very hard about explaining these complex issues very clearly. And with respect to the attorneys, it's the same thing. You'll need to work with your economist and really push them to explain issues clearly, so it doesn't end up being that the view from the fact finder is that, two people said some complicated things and I think it's a wash. So it really is up to all of us, the economists and the attorneys that work with economists, to really hone in on particular issues and try to explain them as clearly as possible so that there's value to the fact finder. And the other thing I will say is that given that the issues are sometimes extremely complex, econometrics can become very complex as well. Sometimes it may be the case that it would be helpful for a fact finder to have a special master that can understand what the economists have done and evaluate, their different approaches or even their disagreements.
So a decision maker that has specific expertise in economics and can better assess the dueling economists than a judge or arbitration, for example.
Yes, and that can be very helpful. I've seen it, used in some cases, obviously not, across the board, but that could be another tool that could be useful and could, avoid getting at that issue.
One of the challenges that I think both lawyers and economists face is you're taking something that's really hard and you're explaining, as a PhD economist, you're doing something really complicated, and a best case is you're explaining it to a smart judge that is educated and has a law degree, but maybe hasn't dealt with economics since their sophomore year of college. Worst case is you're dealing with a jury, with folks that may or may not be educated and may have never taken economists. Do you have any tips on how you can speak to folks about these really hard economic concepts in a way that they're going to really grasp?
I think that's a great question. I think that with respect to the jury, again, I think it's the attorneys would need to work with the economists to really get it to a point where it's boiled down to very simple few issues. Explain them as clearly as possible. Use graphics to explain them. And I think perhaps the best way would be to practice in front of individuals that do not have that background, and that if it can be compelling and convincing to a group that might look like a jury, then you're making some headway in terms of figuring out how to present to the jury in the actual trial.
So let's shift gears a little bit. And sitting as the chair of the economics committee of the antitrust law section. I think we'd be interested in knowing what's fun about being an economist. Why do you love your job?
So I think what's most fun about being an economist is really the problem solving. I expect that's probably quite similar for attorneys as well. But I think that is what's most stimulating, is that you think very hard about the question that can be addressed such that it will get to the issue that is of concern. So I think formulating the right question, and then coming up with a creative, clear way of answering that question. And I think it's really that analytical process that I think is the most fun about being an economist.
And what advice would you have for a young economist that wants to get into working on competition law cases?
I think it's very much in line with what we've discussed. My advice would be to think very hard about explaining things clearly, to think hard about the question at hand, be creative about the different ways in which you can bring economics to life to folks who don't have a background in economics. And so that really is the challenge, and that's the advice I would give.
So tell us something that is unexpected or unusual about yourself that we wouldn't know if we just knew you professionally.
I think the one thing that maybe a lot of people don't know is that I grew up in about 8 different countries.
Okay, which ones?
So mostly, I'll just give you 2 regions because it was moving around, mostly in East Africa and South Asia.
Okay, so now we're going to go to our final segment that we call The Curious Hat.
And now it's time for The Curious Hat.
We have an actual hat that has actual questions in it. Laila has selected a question from this hat. It is question number 7, which is, if you were stranded on a desert island with a DVD player and could only bring 3 movies, what movies would you bring?
That's a great question. I think I'm going to go with some movies that I've watched over and over, and some of this is, earlier in time. Few Good Men, Dirty Dancing, and Top Gun.
Interesting. So I have a couple of follow-up questions. What does it say about your personality if you go with a movie that you've seen over and over as opposed to a movie that you've never seen?
It tells you that I'm risk averse.
Okay. I also wonder, because I did not write this question, I also wonder what you were doing on a desert island with just a DVD player. Like you were thrown overboard and you had a DVD player and electricity apparently, and that's it.
Apparently. Your question, John.
So, and the last thing I'll say is I'm not sure you know the joke about the economist that got stranded on the desert island. The punchline is, assume a lifeboat. So with that, thank you for joining us on Our Curious Amalgam, and we will see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.org. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.